Welcome back to the OMB Law Board. I'm Simon Bennett, and today I've got OMB family law partner Aleena Mills with me. Aleena, welcome back.
Thanks, Simon.
So in a property perspective, we have the family law pool, and the family law pool reflects all of the assets. From time to time, some of those assets may get removed from the pool, and we have this process through amendments in the Family Law Act and recent case legislation, which seeks to add back assets which have been improperly removed.
That's right. So adbacks are a big, relevant topic that most property settlements will involve. So it's really important that we go through those amendments.
Okay, well, let's get into this, because if you're in a situation where the family pool is relevant and assets have been removed, we definitely need to know about how to get them back in the property pool. So, Aleena, I'm going to throw to you. Why don't you tell us what is an adback, how did it come about, and what is the legislation and the case law doing in this regard? Sure.
So we use the term adback to describe joint money, so money that's been in your property pool that has been disposed of by one of the parties. And there's a few categories of that disposal. One is that they might have paid some legal fees using joint money, which is a big no-no. The law says you to pay your own legal fees, so the other party probably shouldn't wear that depletion in the property pool. The second category is where there's been an interim distribution of property. So this is where you might need $50,000 to put a deposit on something and the other party agrees prior to settlement. And then the third category of an adback is essentially where you might have wasted some of the property pool, and that's in conduct that is like, you know, you've got a drug addiction or an alcohol addiction and you've spent a lot of joint money. So the pool from separation to today, when we settle your matter, is down, and it's down and it's not fair to the other party that it's down. So we use adbacks to describe that situation.
Okay, so as we said at the start, we've got this property pool, and that is the joint matrimonial pool, if you like, of assets. Could be property, could be shares, could be money, could be a combination.
Yep.
And that should be preserved as assets of both parties.
Correct.
But one of the parties improperly often has taken assets from that pool.
Yes.
And you're trying to prevent that affecting the other party.
That's right.
Okay.
That's right. And prior to, and I'll talk about this in a bit more detail, but prior to last year when we had our amendments come into the Family Law Act, the exercise or the approach that the courts would take is that they would actually include and quantify the adback, so quantify the amount of money that's been disposed of, and then add it into the balance sheet and assign it to the party that disposed of that money. So it was this mathematical calculation almost where it was included in the balance sheet. Post the amendments last year that came into effect, that approach, it looks like, has been put to death in a way. And I say that because we've had a recent case by the name of Shinohara, which came down shortly after these amendments came into effect.
Okay. And how does that change things? Like what does that happen?
Well, the amendments to the Act actually now tell the court that the court is to, when identifying the asset pool, have regard to existing property of the parties, which means that property that has already been disposed of is not existing anymore. It's notional property. And this case of Shinohara was one of the first to apply this new terminology in the legislation. And what the court in that matter said is that we no longer add that adback to the balance sheet. Instead, we're going to consider the funds disposed of in a broad sort of holistic consideration of the parties' contributions in the case and all their future needs. And that is, in my view, a bit of an imprecise way of dealing with money spent, because adbacks allowed us to quantify that and kind of, in a way, punish the offending party for having had property already, if that makes sense. They've already had and spent that property, and they should wear that.
Yep.
Whereas this decision creates, in my view, a bit of uncertainty around how adbacks are going to be treated.
Okay, so I know this is a difficult question, but in light of the family law amendments and the Shinohara case that you talk about, how do you feel that they're going to deal with this scenario whereby one party has, say, improperly disposed of some of those assets, how is that going to affect the distribution of this?
I think there's going to be quite a large impact on the way we deal with those situations. Because family law is so discretionary, we're not given by the court a lot of guidance as to specific credit that specific contributions get, if that makes sense. So the court will holistically consider everyone's contributions and come to a broad, like a rough split of the pool, but they're not going to tell you necessarily how they and the breakdown of that percentage. So 50-50, for example, they're not going to say, look, because of the adback, I'm crediting the wife 5% here. They don't do that. So it actually creates a bit of uncertainty for us in how we treat funds unnecessarily disposed of. And I think it'll also make parties a little bit more cautious about agreeing to things like partial property settlements, where previously they might have, but now they're not guaranteed that those funds are going to be credited to that party who received it prior to finalisation of their settlement. So I think there's actually going to be quite a few flow-on effects from the decision.
Yeah. It sounds like with a lot of areas of family that it's difficult to get a black and white answer.
That's so true.
Because there's so many factors to be considered.
Mm-hmm.
And holistically, as you said, they're trying to weigh up all of the factors,
Correct.
including any adbacks.
Or negative contributions to
the property pool. So sounds like this is going to be a hotbed.
It will be.
Of activity.
I think so. And I think we're going to have to watch this space for at least a couple of years just to see how the court handles these matters.
Okay, so I appreciate, the advice, and it's good to know about recent changes to the Family Law Act, the Shinohara case, how adbacks are going to change your entitlement to a share in the property pool, and maybe a little bit of lack of certainty at the moment. So, Aleena, thanks so much for bringing us up to date on all that.
No problem. Thanks for having me, Simon.
And if you stay tuned to the OMB Law Board, we will try and answer any questions. If you comment below, any questions to do with the adbacks or the family property pool at all, contact the OMB Family Law Team headed by Aleena Mills.